The topic of my presentation is cultural expertise in Latin America. I'm Dr. Leila Rodriguez. I'm an associate professor in the Department of Sociology and Anthropology at the University of Puerto Rico. I am also a researcher in the Institute for Caribbean Studies in the institution, where I edit the journal Caribbean Studies. Now, this image illustrates what motivates this talk. We know that in Western societies, justice is usually represented as a woman with a balance and a sword in her hands, and her eyes blindfolded, because we believe that justice is blind and that it is applied equally and fairly to everybody. Of course, we also know that this does not match with the reality of what happens in legal systems throughout the world. And we also understand that there are alternative representations of what justice is and should be and could be. In the tarot deck, for example, justice is portrayed with her eyes wide open, completely the opposite to the previous image. And as the cover illustration of my latest book also suggests, for the Latin American region, for example, justice can take into consideration elements of the wide diversity of cultures that populate the region. And so for my presentation, I will give an overview of the use of cultural expertise in Latin America. I will then follow that with some specific examples of cases in which it has been applied. And then I will attempt to make some linkages to some of the K-Peritia working group themes, specifically the theory and professionalization groups. So first, the overview. This map illustrates the countries in the Americas, both North and South America, in which cultural expertise has been applied. I created this map myself, and so I may be missing a few countries there, but I feel pretty good about it. Most notably, two things. One, it has been employed throughout most of the region, and two, the Caribbean region is where it has not yet been officially used yet. In terms of how long or when cultural expertise was legally recognized or first entered a legal conflict, in some countries like Guatemala, it has been around for a very long time, in this case since 1963. And then slowly over the years, you see it being adopted in other countries as well. So Colombia in 1975, Mexico in 1990, Chile in 2001, Peru in 2008, and the most recent one being Costa Rica in 2010. The factors that enable cultural expertise in Latin American legal conflicts are various, right? On one hand, and I'll show this in a minute, there has been a combination of legal reforms, constitutional amendments, and adoption of international norms that in some combination in each of these countries has led to the use of cultural expertise. I also argue that there has to be, in fact, preceding all these reforms, a social but also a judicial recognition of the cultural diversity in that specific country. And of course, you always need an ally or an interested party because there has to be a lawyer or an attorney, a judge that is the first one to allow this evidence to enter a legal conflict. So some examples: in Chile, the Criminal Procedural Code specifies, right, what expert testimony is and the rules for employing it in general. Indigenous law 19.253 dictates the norms for protection, encouragement, and development of indigenous peoples. There's another law that creates the Public Criminal Defender Office, and there's a specific section there about expert testimony in general. And then, of course, ILO Convention on Indigenous and Tribal Peoples has also been invoked in these cases. In Colombia, the Civil Procedural Code defines the means of evidence, and it includes the category other type. And this is something that we find in general, right? That these codes have indications for means of evidence, for expertise of some sort to enter a legal conflict. And when that definition is broad or has this open-ended category, that's often where cultural expertise comes in. Mexico also has a national code of criminal procedure, a federal code of civil procedure where some of this is invoked. Also, the San Andres Sacachian agreements, which were signed between the government and the Zapatista National Liberation Army, does not define nor regulate any of this, but it does mention and normalize this idea that this specific sort of expertise has to be taken into consideration when indigenous peoples or indigenous communities are facing legal conflicts. In Costa Rica, Criminal Procedural Code in Article 213 sets the conditions for requesting cultural expertise. And the Civil Procedural Code also specifies that expertise can be requested when there is a need for somebody that has a detailed knowledge of a science, art, or technique. So again, leaving the disciplines or the fields of expertise pretty broad and pretty open. The country also, of course, has ratified ILO Convention 169 on indigenous and tribal peoples. But in this case, what really set off the use of cultural expertise was the 2008, which have then been updated in 2018, Brasilia regulations regarding the access to justice for vulnerable people. Now, what's important to remember here is that the historical cultural dynamics of all Latin American states from the beginning, from their foundation, affirmed the monocultural in the state and marginalized the diversity, even though we understand that these countries, of course, were diverse from their formation and their foundation. There's a popular saying in Spanish that the legal system is simply customs that are made into law. But that begs the question of whose customs were taken into consideration at the foundation of these states, right? That then is considered the normalized behavior. In Costa Rica, for example, it wasn't until 2015 that the first article of the Constitution was amended to state that Costa Rica is a democratic, free, independent republic, which it had said since 1949, but now recognized that it is multi-ethnic and pluricultural as well. In terms of what populations have been represented in this cultural expertise, indigenous groups, of course, many of them and widely throughout the Americas, ethnic minorities, most specifically Afro-descendant communities or individuals, but also sexual minorities, religious minorities, and peasants or rural groups. So now for some examples of cases. In Colombia, my colleague Esther Sanchez intervened in the Colombian Constitutional Court to resolve an action of protection in order to protect the fundamental right of homosexuals to be teachers. So in this case, a father, I believe it was, of a school claimed that a homosexual teacher should not be working at the school and should not be educating his child. And so the case ended up in the constitutional courts, and it had intervention from many actors and stakeholders. In this case, the cultural expert framed homosexuality as a human phenomenon that is socially and culturally subject to stigmatization. In Mexico, Victor Villanueva co-intervened in a case involving an evangelical pastor accused of sexual abuse and gender violence. In this case, him and his colleague completed an analysis of the group of symbols and discursive representations to which the pastor recurred with the intent to sexually submit some of the women in the congregation. And this case is important because there is an idea that employing cultural expertise automatically means using a cultural defense and somehow justifying or arguing for broadening the understanding of why these things take place. But that is not the case. Cultural expertise, we know, is and should be, I argue, employed simply to illustrate, right? To give better information to those making the judgments. And in this case, this is what the cultural expertise was used for, not to justify or reject the actions of the pastor, but to explain that in the behavior of the pastor was evidence that there was an intent to submit these women in this way. Victor Villanueva also worked on another case in Mexico in which he intervened in a case in which the Black community of Oaxaca demanded that governmental authorities recognize them as a nucleus of Jarocha culture and therefore the right to participate in public consultation. And so Mexico, of course, has a process for public consultation, and the government consulted with communities, Black communities in the state of Veracruz. And the argument here is that just because you consult with one region where there's a Black community or a group of Black communities does not mean that they are representative of the diversity of Afro-Mexican communities. In Chile, Paulo Castro intervened in a case in which a machi or a shaman was accused of terrorism for lighting a house and a warehouse on fire. And of course, there is a lot of history behind this particular event. But in any case, the state invoked the anti-terrorism law, which has been in place for a very long time, but to which the state has recurred more frequently since the early 2000s in the context of the wars in Iraq and Afghanistan. And so in this case, the expert contextualized the acts within Mapuche cosmovision, but also the struggle to defend their territories. In Peru, Ivan Rivas Plata intervened in multiple cases involving a structure called peasant patrols, which are a form of social organization that initiated in the 1970s to protect remote rural areas from livestock robbery, but since then have expanded their role as a mechanism of social control and also mechanisms of punishment. And so in these cases, Dr. Rivas Plata and other experts have contextualized the extent of the legitimacy of these groups. In my case, I have worked in multiple cases of applications for asylum or defense against deportation, specifically for Guatemalans in the United States. And in my interventions, I have explained that a set of identities, for example, being young, male, indigenous, homeless, or being a woman, indigenous, HIV positive, constitute culturally significant social categories that the state either persecutes or is unable or unwilling to protect. Most recently, I have been working with the Legal Services Clinic at the University of Puerto Rico as they attempt to work on the introduction of a bill that would grant a historically Black neighborhood community rights to their land. And so this is a legal figure that has not been employed in Puerto Rico before. And it would also, if accepted, be the first legal use of cultural expertise, in this case to document identity and rootedness to the land and to this community. Okay, now for some linkages to some of the K-Peritia working group themes. First of all, anybody following the work of cultural expertise in Latin America, a little bit of clarification of the terminology that's used in Spanish. The most common term to use is peritajes culturales, which translates naturally into cultural expertise, which is the preferred term in the European context. But you will also read that it is called peritajes antropológicos, so specifically anthropological expertise. Most specifically, peritajes culturales antropológicos, which is a mouthful, and that translates to cultural anthropological expertise because in the region, it is almost exclusively anthropologists who conduct this work. You will also hear it being called peritazgo in Colombia, or expert evaluation. In Guatemala, prueba judicial antropológica, so an anthropological judicial evidence. And in the case of the United States and Canada, you'll hear the term in English, cultural expert testimony. So in the words of Guatemalan jurist Amilcar Pop, who's indigenous himself, cultural expertise should actually not exist if the state or states had been constructed according to the multicultural composition of Guatemalan or really any Latin American society. But until such a state is developed, it becomes, and here's his definition, a necessary resource to promote a culturally pertinent justice, right? That a true justice has to have its eyes open to the cultural diversity of the land, right? And to consider and make room for the normative behavior of that cultural diversity. Otto Marroquin, a Guatemalan jurist as well, defines cultural expertise first and foremost as a means of evidence, right, which enters a legal conflict as that figure, by virtue of which the judge gains knowledge of the manifestations of an individual in their capacity as a member of a particular social group through an expert report on the culture being studied and which the judge uses when making a decision. And so this definition is a bit of a mouthful, but it contains a lot of important information, right? First and foremost, that to the extent that there is consensus in the region about what cultural expertise is that it has to be included as means of evidence. It is not an informal report, right? And that its main purpose is to give additional information to judges, right, that they then use when making a decision. And specifically, that the information is how the behavior, the manifestations of an individual facing the legal conflict occur because they are members of specific social groups. Now, cultural expertise is, in many cases, used as a cultural defense, but not always, as we saw with the Mexican example, that argues for the value and validity of different customs, behaviors, and traditions, and their recognition on the part of the legal system, right? And there's a chapter in this book edited by Dr. Holden that explains that for the Latin American context and Chile specifically. Now, the Brazilian regulations, and there were 100 of them, right, frame, in this case, cultural expertise as a means to improve access to justice for vulnerable people, right? And they define vulnerable people as those who, due to reasons of age, gender, physical or mental state, due to social, economic, and here's the cultural part, right, ethnic and or cultural circumstances, find it especially difficult to fully exercise their rights, before the justice system as recognized to them by law. There is also the implicit definition of what cultural expertise is from the perspective of legal systems, right? In the case of Costa Rica, anthropologist Marcos Guevara argued that cultural expertise was framed by the state as a means to contextualize culture as an error, okay? And so he states that in Costa Rica, judicial doctrine has developed the concept of what's called a culturally conditioned error of prohibition, right? And what this concept states is that it must be taken into consideration, right, when somebody, because of their culture, did not know that they were breaking a law, or did not consider that they were breaking a law, or did not understand the extent of the consequences for breaking such a law, but that this is an error that is conditioned by their culture, right? And so, in other words, current law considers non-hegemonic cultures as an error, as a mistake. And he argues that the most obvious consequence of laws that were drafted from this monocultural perspective to regulate the coexistence of members who are actually from a multicultural society is exclusion, right? That those who do not abide by dominant canons and customs can only gain access by being exceptions. Okay, in terms of the impact of cultural expertise in Latin American legal conflicts, first of all, we don't know much. There has been little work to systematically analyze the impact of cultural expertise on different rulings. And so I am actually working on changing this and trying to measure this. But there has been some work done, particularly by colleagues in Chile. And so we do know that often they have either an exonerating effect or that are considered as attenuating circumstance of criminal responsibility. In the case for Colombia, um, there is the argument by Dr. Esther Sanchez that there has been institutional change as a result of all the cases that have employed cultural expertise that has now altered the state's mode of conducting justice, that has eliminated the need for individual interventions of cultural experts, so that this systemic change has to some extent been reached. And if nothing else, I argue that cultural expertise has definitely had the role in all of these societies of broadening, or in some cases, even initiating discussions about the relationship between cultural diversity and justice in each specific state. In terms of contributions of Latin American cultural expertise to global and specifically European discussions about professionalization, we do know that the requirements for serving as a cultural expert vary widely across the different countries. In Costa Rica, an article of the Code of Criminal Procedure states that experts must hold a qualifying degree in the subject related to the matter on which they will provide an opinion, as long as that science, art, or technique is regulated. Otherwise, a person with manifest competence must be appointed. So it is a very broad definition. It doesn't state what level that degree should be, right? If it has to be the highest degree offered in that discipline. In the case of anthropology, which, as I mentioned in the region, it's almost exclusively anthropologists who do this work. That discipline does not have a formal association the way sociology and others do. So it does basically fall upon that second part of the requirement that a person has to have a manifest competence, right? And that this competence is ultimately ratified by the judge in the case. In Peru, only anthropologists who are ascribed to the Institute of Legal Medicine and Forensic Sciences are called upon to serve formally as experts, and they receive some training in-house. In terms of formal training, in Mexico, the National Institute of Anthropology and History has a diploma that they offer on judicial or legal anthropology and anthropological expertise. And for this, they required a minimum of a licentiate degree. And in this case, the training includes sociocultural expertise, but also forensic and archaeological expertise. In Argentina, the National University of Rio Negro offers a postgraduate certificate, again, in anthropological expertise, so a little bit more broadly than just cultural expertise. I do know of some private training services, specifically in the case of Peru, which are open to anybody worldwide, but I do not know the specific content of this training. It is also important to define the professional competencies that we believe cultural experts should have. At a minimum, an understanding of how to study culture, right, which requires theoretical knowledge, also substantive knowledge on specific cultures, and then an ability to interpret. Also, some sort of ethnographic inquiry, right, which might involve field work or some other form of data collection. They should have a perspective about cultural change, which is a big issue that comes up in these cases invoking cultural expertise, that if something was stated about a culture 40 years ago, it does not necessarily hold true today. And so they must have this historical perspective. And also, they should have anthropological interpretation in the sense that they should be able to understand and explain to outsiders the culture of a local community, but then also some sort of sociological interpretation, right, that explains the insertion of that community with and its relationship with the broader national society. On the flip side, there are also some other resources available which could be very informative for all of you. Mexico has these normative protocols for those who impart justice, and they have some that are specifically protocols for judging with an intercultural perspective. And they have the one on the left talks about communities, people, and persons who are indigenous, and the one on the right, excuse me, people, communities, and persons who are Afro-descendant and Afro-Mexican. They also have some additional ones which are not framed as this intercultural perspective that I would argue that they are, right? And so there's a protocol for judging cases that involve migrant persons and those who are subject to international protection, judging with a gender perspective, and judging with a sexual orientation, sexual identity, gender expression, etc. Perspective. Last year, I conducted a workshop in Costa Rica for district attorneys from areas with high indigenous populations. And I talked essentially a little bit about what cultural expertise is, what it's used for across Latin America, what it has been used for in Costa Rica, and I gave them some background on the cultural diversity of Costa Rica and the diversity of indigenous peoples specifically. At the end of the talk, I asked them what they learned, what questions remained after my talk, and what opinion they have now formed about cultural expertise, right? In terms of what they learned, they mentioned the existence of cultural expertise locally and globally. This was something that they were completely unfamiliar with. The scope in terms of the range of cases and courts that have employed cultural expertise, the duration of the creation, right, or the presentation of this expertise, that sometimes long-term fieldwork is required to collect the necessary data, but not always. The importance and why they matter. The preparation, I mentioned to them the specific steps that we take to construct these testimonies and also the professional competencies behind these experts. And of course, the context, right? They hadn't given much thought to the cultural diversity of the country, how it got there, and how it has or has not been considered in the legal systems since the foundation of the country itself. In terms of the questions that remain, these were, again, very interesting, right? So the scale, they wanted to know if it's possible to create a general cultural analysis for an entire region and then just have that be employed multiple times as this cultural evidence. The applicability, they asked me, for example, is it possible to provide cultural expertise not on an indigenous group or religious group, but something like a criminal group? Of course, the answer to this is yes, but collecting that data is a bit more difficult, right? And perhaps getting it accepted by a judge in a legal conflict as well. The need, they were confused about when should they or should they not request cultural expertise. And they had some important questions about the validity of cultural expertise, which is a topic that I myself am passionate about. But they wanted to know, can subjects manipulate the experts, tell us something that's not true? Is there some sort of equivalent of ISO norms or certificates that guarantee the quality of the studies? And then, of course, questions about impact. They wanted to know, why does cultural expertise impact a legal process if, as cultural experts, we do not emit a specific opinion about whether some behavior is good or bad? In terms of opinions, and this is perhaps the most hopeful part of this talk, is that they concluded that they are useful to them, right? They're useful as a fundamental means of evidence. They're useful because they can help make more fair decisions, because they empower victims, because they can potentially deliver faster justice, or, what my hope is that they improve in some way case resolution. And finally, I leave you with a quote from one of my favorite movies, The Secret in Their Eyes, an Argentinian movie, in which two attorneys are talking at the end of the movie about whether justice was actually imparted after everything they went through. And one of them says, well, it is not the justice, but it is a justice, right? So we may not always or ever reach a gold standard of a perfect justice that we all agree is great, but we can certainly improve some sort of justice. And finally, I share these QR codes to some of the resources that I mentioned. There's one for the Mexican protocols for those who impart justice. There's a QR code for my book. And there's also a QR code for a Google Drive, which I will be constantly updating with some readings on cultural expertise in Latin America. Thank you very much.